Well, gentlemen, there are numerous disputes amidst people in our society, and in order to seek the redressal, they have to resort to the courts. Resultantly, the courts are overburdened, and at the same time, the litigants have to bear the brunt of protracted litigation. Sometimes the disputes of minor nature are resulted in heinous offences, so endless feuds start. The jurists and lawyers are of the opinion that the disputes in the villages should be settled in the villages through arbitration. So the Arbitration Act 1940 was enacted. It was held in 2005 YLR, page 1850. Once parties agree to refer a dispute to the arbitrators, Arbitration Act 1940 comes into action, and jurisdiction of all courts and authorities ceases. Arbitration may be without intervention of the court or with the intervention of the court. When the Land Revenue Act 1967 was enacted, it was felt that instead of resorting to Arbitration Act 1940, special jurisdiction is to be provided to revenue officers to resolve the dispute in matters of land. So, Section 160 was incorporated in the said Act, and Arbitration Act would not apply in matters of arbitration of land revenue. So we have to see Section 160 of the Punjab Land Revenue Act 1967. Nothing in the Arbitration Act 1940 shall apply to any arbitration under this chapter. It means that the Arbitration Act is not applicable before the revenue authorities when the revenue officer is exercising the powers under the Land Revenue Act. He shall be exercising the powers for the appointment of arbitrator not under the Arbitration Act but under the Land Revenue Act. Section 151 of the Arbitration in the Land Revenue Act states that any revenue officer may, with the consent of the parties, refer to arbitration any dispute arising before him in any matter under this Act. This plain reading of this provision shows that the powers to appoint arbitrator have been entrusted to the revenue officer, and with the consent of the parties, the revenue officer has the jurisdiction and the competency to appoint an arbitrator for the purpose of resolving the disputes which have arisen under this Act. This Act means under the Land Revenue Act. So whenever there is a dispute in the Land Revenue Act and under Section 172 Land Revenue Act, the jurisdiction of the civil court is barred, so the jurisdiction of the revenue officer shall be available. So where the revenue officer has the jurisdiction to determine the dispute through arbitration, so there are two aspects of the matter. One is with the consent of the parties, and the other is without the consent of the parties. So far as the consent of the parties is concerned, it is provided in Section 151, subsection 1, that any dispute arising between the parties under the Land Revenue Act shall be determined by appointment of arbitrator by the revenue officer with the consent of the parties. But there are certain matters wherein the consent of the parties is not required. So those matters are dealt with in the Punjab Land Revenue Act 1967 under section 151 subsection 2. Subsection 2 states a collector or any assistant collector of the first grade may, without consent of the parties, refer to arbitration any dispute before him with respect to any matter which an entry is to be made in any record or register under Chapter 6. What does the Chapter 6 say? We are to consider the same because this section provides that when the matter relates to the section Chapter 6, then in that situation the revenue officer may appoint an arbitrator without consent of the party. Chapter 6 of this Act relates to the record of rights and the periodical record, meaning thereby when the record of rights and the documents included thereon are going to be prepared, or when making of special revision of record of right is in progress, or the periodical record is being consolidated, prepared, or being adjudicated, or being checked, whatsoever the situation may be, the preparation of the computerized record. So the Chapter 6 deals with the record and the preparation of the record. So when the matter relates to the preparation of record and the dispute arises between the parties, then the consent of the party is not necessary. A revenue officer is competent in this matter to appoint an arbitrator or any matter relating to the distribution of an assessment under section 67. So when there is a dispute regarding the assessment under section 67, the revenue officer is not bound to seek the consent of the parties for the appointment of arbitrator, but he himself has the authority, jurisdiction, competency, and the power to appoint an arbitrator without consent of the parties. Number C states, the limits of the state or any building, field, or other portion of an estate when are subject matter of the dispute, then the revenue officer does not require any consent of the parties, and he may appoint an arbitrator for the purpose of resolving the disputes relating to the estate or of any holding or field, whatsoever that may be, as has been enunciated in section 151, subsections 2 and subclass C. So in the villages, usually there are disputes between the co-owners and the co-sharers regarding the partition of the property. The property to be divided at a partition or the mode of making partition are usually in dispute. And when a dispute arises between the parties regarding the mode of partition, then the revenue officer has the authority to make an order appointing an arbitrator to resolve the dispute. So in this situation, when the matter relates to the division at a partition or the mode of making partition, then he is not required to seek the consent of the parties. He may appoint an arbitrator for the purpose of resolving the dispute, for the purpose of partition. Now we have seen that arbitration proceedings are separate and different in the Land Revenue Act from the proceedings under the Arbitration Act 1940. So when a matter is referred to arbitrator, a revenue officer shall make an order of reference and specify therein the precise matter submitted to arbitration. It means that the terms of reference shall be determined by the revenue officer, and after determining the terms of reference, he shall submit the matter to the arbitrator. He shall make the number of arbitrators which each party to the dispute is to nominate, and the period within which arbitrators are to be nominated, and the period within which the award is to be delivered. So section 1, the bare reading of section 151 shows that number 1, he shall determine the dispute which is to be referred to the arbiter. Then he shall direct the parties that how many arbitrators are to be nominated by the parties, and the period within which the award shall be pronounced. The number of arbitrators which each party may nominate must be the same and must not exceed 2, meaning thereby that one party, if nominates one arbitrator, the other party will also nominate one arbitrator. If one party nominates 2 arbitrators, the other party shall nominate 2 arbitrators. So similar will be paid. But now in this situation, sometimes it happens that there are 2 or 4 arbitrators in even number. So for the purpose of avoiding the conflict of opinion, there should be an odd numbers. So the revenue officer shall himself nominate an arbitrator. If one party gives 2 arbitrators, other gives 2 arbitrators, then the revenue officer shall also nominate one arbitrator himself. In this way there shall be 5 arbitrators, and the decision of the 3 arbitrators shall be considered as the award. The revenue officer may, for the reasons to be recorded by him, make an order disallowing any nomination made by either party and requiring the party to make another nomination. So it means that the parties are not at liberty whenever a party nominates an arbitrator. The revenue officer shall scrutinize it and shall decide whether or not the arbitrator is fit for the job. Why this provision is there? It is because there may be certain circumstances that a party nominates an arbitrator which may not be available. Suppose a person is residing in USA and the party comes before the revenue officer and nominates him as the arbitrator. It shall not be possible for the revenue officer to summon him, to get his statement recorded, to ask him to perform the duties. So it shall not be possible for the revenue officer to do the same. So he has given the authority to reject the name of any arbitrator and then ask the party to give another arbitrator. An order under this section shall be final. If an arbitrator nominated party dies or a party desires to change him or to discharge him, or he himself refuses or becomes incapable to act, the party may nominate another person in his stead under Section 154 of the Land Revenue Act 1967. It means that once the arbitrator is appointed, he is not final for all purposes. There are certain reasons which entitle a party to discharge him, to change him, and if he himself refuses, or he dies, or becomes incapable, then the party may nominate another arbitrator. If the parties fail to nominate an arbitrator within the period fixed, or if the nomination of arbitrator has been disallowed, or if a party entitled to nominate an arbitrator in place of another arbitrator fails to nominate him, or if an arbitrator nominated by the revenue officer dies or is not capable of to make the statement, then the revenue officer may nominate a person as arbitrator. So there is a process prescribed for appearance before arbitrators. Under Section 156 of the Land Revenue Act, the revenue officer shall, on the application of the arbitrators, issue the same processes to the parties and witnesses whom the arbitrators desire to examine as he may issue in any proceeding under this act before himself. Any such party or witness shall be bound to appear before the arbitrator in obedience to a process issued under the subsection 1 of section 156, either in person or by agent as the arbitrator may require. The person attending in obedience to the process shall be bound to state the truth upon any matter respecting which he is to examine or make statements, and to produce such documents and other things relating to any such matter as may be specified in the progress. So this section is an enabling section which provides the issuance of process for appearance before the arbitrator. It means that the arbitrator has the jurisdiction to examine the witnesses, has the jurisdiction to inquire into the matter, has the jurisdiction to collect the documents, meaning thereby that the arbitrator shall provide an opportunity to the parties of being heard and of producing evidence, whether oral or written. Then, after conclusion of the inquiry, as stated in section 156, the award of arbitration is to be pronounced. So, for this purpose, section 157 is very much clear. The arbitrator shall make an award in writing under their hands concerning the matter referred to them for arbitration, and state therein their reasons thereunder, and then the arbitrator, dissenting from the award made by a majority of the arbitrator, shall state the grounds of his dissent. The arbitrator shall present the award to the revenue officer in person or by agent, or send the same to him by registered post. So the procedure is very simple. Number one, the arbitrator is appointed, then he is given the authority to inquire into the matter. He is entitled to record the evidence. He may be allowed to inquire into the matter, examine, re-examine, cross-examine, or any party who wants to give the evidence through documents may produce the written evidence. That may be whatsoever that form may be, it is to be determined by the arbitrator. So arbitrator, after hearing the parties and inquiring into the matter, shall pronounce their award and shall present in the court. So the decision of the majority shall be considered as award, and that award is presented in the court. When the award has been received by the court, by the revenue officer, then the revenue officer shall fix a date for the consideration of the award. On the date fixed or on any subsequent date to which an adjournment may be made, the revenue officer shall hear any objections which the parties may have to make to the award. Now, one thing is to be made clear, that the revenue officer cannot sit in the judgment of arbitrator. The judgment of the arbitrator cannot be challenged otherwise than the law. So the party objecting the award shall have the party objecting the award must give reason of his objections. Normally, there are a few grounds for the objection of award. Number one, he may say that no opportunity was given to him to produce the evidence. The arbitrator did not hear him and he has been condemned unheard. Or there is another reason, that the arbitrator has committed misconduct. He has committed misconduct himself or with the proceedings. Then sometimes it happens that the arbitrator exceeds the jurisdiction. So any award pronounced by the arbitrator, if it is beyond his jurisdiction, it is nullity in the eye of law. So an opportunity is given to the parties to give the objections, raise the objections. It should be remembered that the reference is to be made to the arbitrator to be prepared by the revenue officer. So there must be the terms of reference. So at the time of appointment of the arbitrator, the revenue officer shall pronounce the terms of reference, and the arbitrator cannot go beyond the terms of reference. No doubt he has the jurisdiction under 156 to inquire into the matter as stated in that section, but he is to confine himself to the terms of reference. If he goes beyond the terms of reference, the party may raise objection. Then if an objection is raised, then what will happen? There may be two kinds of objection generally. There may be more than two, but generally there are two. Number one, the award is invalid, void, against law, beyond jurisdiction, and he has committed misconduct with himself and with the proceedings. And number two is another one, that may be that the award does not explain the reasons. So when the award is without reason, then it shall not be set aside. If the award does not give the reasons, it shall be remitted back to the arbitrator for the purpose of elucidating his point or giving the reason for the award. But if there are the questions which show that the award is without jurisdiction, then it shall be set aside. So now the question is, what is the effect of the award? The revenue officer may accept the award. He may modify the award. He may reject the award, and he shall give a reason of his order for doing so, and he shall make a decision respecting the dispute which was referred to the arbitration. And then he will decide whether the award is made rule of the court or not. An appeal shall lie from the decision of the revenue officer made under Section 159 as if arbitrator had not been appointed. So the appeal is competent from the making of the award. Now we have to see the distinction between Arbitration Act and the Land Revenue Act. Arbitrator under the Land Revenue Act is appointed in relation to the land, number one. Number two, in the matters which are within the jurisdiction of the revenue officer as stated under Section 172 of the Land Revenue Act. Section 172 Land Revenue Act provides the matters and the disputes and the issues and the propositions wherein the land revenue officer has got the jurisdiction. So the matters wherein he has got the jurisdiction to decide the dispute, he may refer those disputes to the arbitrator. But so far as the Arbitration Act is concerned, its scope is vast. Wherever there is a dispute between the parties regarding their rights or their infringement, they may refer the matter to the arbitrator themselves or sometimes with the intervention of the court. So when a revenue officer is appointing an arbitrator, the arbitrator shall not assume the jurisdiction under the Arbitration Act, but he shall assume the jurisdiction under the Land Revenue Act. The purpose of this appointment is that the litigation should be curtailed and the parties should be encouraged for the purpose of determining their dispute at their home, in their village, within their vicinity, and they should avoid the costly and time-consuming litigation. Because it usually happens that when a case goes to the court, it takes too much time and a party cannot bear the brunt of protracted litigation. And the litigation is so lengthy that he cannot get his right. But so far as the land is concerned, he is interested in getting the land, he is interested in harvesting the land, he is interested to get the fruit of the land, he is interested to get the usufruct of the land. So as soon as he gets it, he will be satisfied. So for the purpose of curtailing the litigation, the provisions of arbitration under the Land Revenue Act will serve the purpose.